I caught him in a lie. During pretrial testimony, I caught him in a lie. You want to know whether it made a difference in the outcome of the case? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answer is yes, it did make a difference in the outcome. So what's all this about? This was a medical malpractice case, and now during the course of this lawsuit, I had an opportunity to question the doctor who was being sued in this particular case. In this case, it involved a failure to timely diagnose cancer. And what we were claiming was that this doctor made some notes, made some entries in his chart, and now those entries didn't seem to be accurate and didn't jive with what the patient remembered happening. Now, that was fine, but that wasn't sufficient to really establish that this particular doctor was a liar. So, I went into this pretrial question and answer session believing, at least initially having the suspicion, that what this doctor wrote in his note was inaccurate. Now, why is that? It's because when I first met with the client, I had learned from her firsthand exactly what she remembered, and this was shortly after she was diagnosed with cancer. And she had a very good memory and details of the events that transpired in the doctor's office. And she remembered specific things. So now, during the course of her lawsuit, it was about a year later after she had started her case. And now she had already given pretrial testimony, which means the defense lawyer, the attorney who represented the doctor who we sued, now the defense attorney had asked my client many questions consisting of hundreds, if not thousands of questions that lasted all day. And my client testified exactly what she recalled, and it was consistent with the information that she had told me privately when she first came to me at the very beginning. So now I had a clear understanding of exactly what she believed and what she remembered was done during her office visits with this particular doctor. Now, what's interesting about this particular case is that the doctor's office notes were very, how do I describe it? They were unusual. They were not as detailed. Actually, I shouldn't say that. They were much more detailed than you would normally expect to see. So let me step back for a minute. Back in the day, or years ago, before all the doctors were using electronic medical records, doctors were using paper records. And there were occasions, not many, but there were occasions when a paper might accidentally go missing, and that note might have been rewritten or simply could not be found. And typically in an office record, in an office setting, the doctor would not sit and explain and write lengthy details about the particular office visit. That was generally the case. So now when I saw that there were lengthy explanations about conversations that the doctor had with the patient, now we begin to question why this is so unusual. Why does the doctor writing all these details that ordinarily would not be there? And I'll tell you something else that made me a little suspicious. When we had copies of the medical records, we had no way of knowing whether these copies were altered, whether one pen was used, whether multiple pens were used, whether it was made at the same day. There was no way to tell just from a photocopy about when a particular handwritten chart was made. So during the pretrial deposition, this question and answer session that took place in the doctor's attorney's office, one of the key things that I would always ask for, and did in this case, was I want to see the original chart. Now, before we started questioning that morning, I now ask the attorney to see the original chart. And I start going through page by page. And they're not many, but there were some key areas I wanted to specifically focus on before we started. And as I turned each page, I'm thinking to myself, this is very odd. Something unusual has happened here. I don't understand it. And I'm going to find out the answer about why things are so unusual. What was unusual? Let me share with you what was unusual. In the doctor's original office chart, it turns out that things were entirely different. Entirely different. The notes for two particular office visits were totally different than the records that we had. Now you might be saying, wait a second, go back for a second. How is that possible? How is it possible that I, as the plaintiff's attorney, the attorney who represents the injured patient, had a copy of the doctor's office chart that was totally different than the original chart that I'm looking at for the same exact date, for the same exact patient? How is that possible? The answer is, it should not be possible. But here we are. I'm at this deposition, the doctor's in front of me, his attorney is sitting next to him. I'm looking through the chart, the original chart with the original ink, and I can see it's all done in one handwriting, and it's all done with one pen, and I can see everything's nice and neat and clean, which you rarely ever see in a doctor's handwritten note because their writing is typically atrocious, mine included. But putting that aside, the doctor's records are often, when handwritten, terrible, and it's very difficult to understand and decipher them. But yet here we are with this note that is pristine, it's precise. Something is very, very off. And now I begin questioning the doctor. And a few hours later, I begin to get into the details of the doctor's actual treatment of my client. I begin to go through line by line of his particular notes to get him to explain to me exactly what they say, what they mean, what he did, and what he was thinking. Importantly, what he was thinking and why he did those things and why he rendered certain treatment. And that was critical. Why? It was critical because now I locked the doctor into his testimony about exactly what he did. And by the way, before I actually started asking him any questions, I said to him, "Doctor, before coming here today, did you bring with you all of this patient's records?" "Yes." "Did you bring her original records?" "Yes." "Do you have any other records for this patient?" "No, I don't." "Did you make notes about this patient's visit at any other time and did not bring them with you?" "No, I don't." "Do you have any other copies of this patient's records?" And so why did I do that? I did that because I wanted to lock the doctor into his testimony, and I wanted him to dig a hole for himself that he would not be able to get out of later. So why was that important? It's important because after I went through all the records that he gave to me and gave to his attorney, and now he testified freely by explaining all the details. And by the way, you should know, if you were to believe everything that the doctor said, there would be no liability and my client would have absolutely no case. That's how it read, meaning that he had basically exculpated, he had basically written a detailed narrative in his notes that said he did every single thing correctly, and he gave reasons for why he did what he did. And if you were to read that on its own without knowing anything else about the case, the answer is, and any expert would have told me, that he did everything appropriately and my client did not have a valid case. However, here's the but, however, once I was done questioning him about the details of what was contained in his particular office chart, then I reached into my bag and I handed to the doctor a copy of the office visit that I was concerned about. I said, "Doctor, I want you to take a look at this photocopy of this patient's record for this particular day. Do you see that?" "Yes, I do." And I showed his attorney a copy of that. I said, "Doctor, this is your handwriting, isn't that right?" "Yes, it is." "And this handwriting, this was done all at one time, isn't that correct?" "Yes." "And do you have the original for this particular page?" "No, I don't." "Do you know where that original is, doctor?" "No, I don't." "Did you see the original page for this particular office visit anywhere in your chart?" "No, I don't." "You told me earlier, doctor, that you made no additional notes about this particular patient, isn't that right?" "Yes." "Can you explain to me how this particular photocopy of this particular page on this particular date exists and how you wrote it?" "No, I can't." "Doctor," and now I went to the next page. "Doctor, let me show you this page for this office visit." And then I said, "Let's take a look at the exact date for the chart that you have and the date of the office visit record that I have. And let's put them side by side, shall we? And would you agree that the date for the office visit occurred on the same exact date?" "Yes, I would." "And would you agree that that is your handwriting for both notes?" "Yes, I would." And what am I doing? I'm taking him down step by step, and now I am getting him to acknowledge that the records that I have are also ones that he wrote. Now, how is that possible that he could have written two different sets of records for this patient's office visit on the same particular day? And then I went through one by one, asking him whether he knew where the original records were for our copy that we had in our file. And he couldn't answer the question. I said, "Doctor, can you tell me why the information contained in my copy of the patient's chart is totally different than the information contained in the record that you produced today?" And he looked at me like a deer in the headlights with his mouth open, and he could not answer my question. He had absolutely no answer, and you should have seen the look on his attorney's face when she realized exactly what I had just done. I had established through clear and convincing evidence that this doctor was an absolute 100% piece of liar. He had lied to her, he had lied to me, he had lied to everybody who read that particular document, because he said this was the only document I had, this is what I wrote, this is what I did, this is exactly what I explained to the patient. And why did he do that? Well, my guess is he wanted to avoid liability. But what the doctor did not know, and what his attorney did not know, is that within a few days after my client was diagnosed with cancer, she personally went to the doctor's office and requested a copy of her medical chart from this particular doctor. The secretary at the front desk gladly gave her a copy of her chart. She signed whatever forms were necessary and gave her a copy. But for whatever reason, the doctor did not know or did not remember that that had occurred. And because of that, this doctor intentionally wrote up a note that was favorable to him. One of the most remarkable things about this entire story was that when I confronted the doctor with our copy of that particular note that he could not explain, I asked him questions about whether or not the treatment would be appropriate if he had done what he indicated in his particular chart. And you know what his answers were? No, in that instance, it would be a departure from the standard of care. And I went after him on that line of questioning. And I asked him multiple questions about his opinions, that if those things had actually occurred and been done according to the way my client remembered it happening, would he agree that it would be a departure from the standard of care not to do X, Y, and Z? And you know what he had to say? Yes, I would have to agree. So now, did it make a difference in the outcome? The answer is absolutely. The defense attorney, at the conclusion of my questioning, asked the doctor to wait outside, and she and I had a heart-to-heart conversation. She turned to me and said, "Get me a number. Let's negotiate this case." And ultimately, that's what we did. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand one instance where a doctor outright lied. He rewrote an entire note just to try and get away with the fact that he did something improper that caused my client significant harm and injury. And because that strategy backfired on the doctor, I was able to successfully negotiate this case at a much earlier point in time and for a favorable amount on behalf of my client. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. You know, I realize you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.